All right. We're back, America. You're listening to America's Voice Now. My name is Michael Evans. I'm your host here this morning. We're in our second segment this morning. Part of what we try to do here is to help prompt, if you will, or motivate some thinking outside of the propaganda you're fed every day. Because I believe that the American people, given the opportunity, are worthy of the freedom and the liberty that we've been given. Thomas Jefferson wrote a letter to a guy by the name of Edward Carrington back in 1787, I think it was. And, Jefferson was a prolific writer and probably one of the most prolific of the founders. And in this letter, he was describing the dangers that were inherent in where we are, especially related to government and tyranny and oppression. And, well, of course, they didn't have the word apartheid back then. And here's what he wrote. Cherish, therefore, the spirit of our people and keep alive their attention. Do not be too severe upon their errors, but reclaim them by enlightening them. For if once they become inattentive to public affairs, you and I and Congress and assemblies, judges and governors, shall all become wolves. Wow. Think about that for a moment. He was warning a fellow that he saw the future of an inattentive, apathetic American public. A public who had lost their way, lost their direction, lost their ability to see through the propaganda, lost their ability to make decisions for themselves, to stand up when they saw wrong being done. Cherish, therefore, the spirit of our people and keep alive their attention. He was pointing to the idea that propaganda and misdirection and misinformation would be a natural occurrence anyway, just based on society's, being pulled in the direction of trying to make a living or what have you. But when you incorporate with that a willful, intentional, with malice aforethought action on the part of your government, that changes the very nature of his statement. It completely turns it around. Cherish, therefore, the spirit of our people and keep alive their attention. Keep alive their attention. Keep them focused on what's happening around them so that they're situationally aware of what's happening in our government. And one of the reasons that we can't do that today is because, first of all, government has gotten so big that there's just too much for any one person to watch. I mean, government can't even watch itself. It's so big. He goes on to say, do not be too severe upon their errors, but reclaim them by enlightening them. In other words, let's not get carried away that they occasionally slip away and fall asleep and we lose their attention. But let's reclaim them by alerting them to the danger at hand. And he concludes the concept by saying, for if once they become inattentive to the public affairs, then you and I, and Congress, and assemblies, judges, and governors shall all become wolves, predators. ladies and gentlemen, have they not become our predators? Are we not the prey? I have 3 stories that I've posted up on our America's Voice Now website, our Facebook page, Patriot FB. There are 3 topics we're going to talk about in here. About judges who are revolting against the system which they recognize is way outside of its constitutional boundaries. That's an article that was posted in Washington Post. And it talks about magistrates, which, if you're not familiar with the court system, these are the judges who do all the heavy lifting. These are the workhorses of the justice system. Not the judges who ultimately, most magistrates don't actually hear cases per se. But these are the guys who sign off on the warrants. These are the guys who do the preliminary case hearings and things like that. They're the guys who are actually out there working the system hard. While, most of the judges that you hear about and think about, they only, they don't do all of this minor type work. But because of the fact that these guys are on the front lines, if you will, they're the grunts in the trenches. Many of these low-level federal judges are balking at law enforcement requests for electronic evidence. And they're actually sitting there fighting for our Fourth Amendment rights. On the opposite side of the spectrum, we have appeals court judges who are violating ethics laws. This is an article from the Associated Press. More than a dozen federal appeals court judges have violated federal conflict of interest laws over the past 3 years alone, throwing into doubt decisions in over 26 cases. Why? Because these judges were ruling on cases in which they had a conflict of interest. Generally, and most usually, in a situation where they were ruling on a civil case, where to use one example, in 2011, James Hill, a judge from the 11th U.S. Circuit Court, he is in a court of appeals down in Atlanta. He sat on a 3-judge panel that affirmed a lower court verdict in favor of Johnson & Johnson. Here's the problem. At the time, he owned $100,000 worth of Johnson & Johnson stock. Hello? When you look up the term conflict of interest, Judge James Hill's picture is in the book. In other words, he found in favor of Johnson & Johnson. And this was a lawsuit on a malfunctioning medication pump, which would have cost Johnson & Johnson perhaps, hundreds of millions or tens of millions of dollars. And he found in Johnson & Johnson's favor. Well, as as a stockholder worth $100,000 worth of their shares, what do you think his stock would have taken on a hit had Johnson & Johnson lost and the public splashed all over the front of the newspaper? Johnson & Johnson loses massive court battle. $25 million settlement. $200 million. Who knows? Most of the judges say, we didn't realize we had a conflict of interest. Really now? You didn't realize you had a conflict of interest? You mean you didn't know you had $100,000 worth of Johnson & Johnson stock? Really? That strains credulity, sir. And quite honestly, if you're that uninformed, if you're that lackadaisical, if you're that cavalier, perhaps that calls into question your judgment to sit as a judge in the first place. The Center for Public Integrity has pulled this report about 24 judges involving 24 judges in cases in which judges ruled despite owning stock in a company that appeared before them. And in 2 of those cases, judges had financial ties to the law firms that represented one of the parties. Okay, so here's how this works. Hey, Charlie, look, I know you're defending Johnson & Johnson or other megalithic corporation, and, you know, I'm a senior partner there. Or my son is one of the partners there. So don't mention that when you get in front of the court, because obviously I'd have to recuse myself. Does law matter to anybody other than us? I mean, realistically, ladies and gentlemen, it doesn't appear that the law matters to anybody who's in a position of creating it or abusing it. It only seems to matter when it applies to the peasantry out there. I mean, really. The problem is that there's not even a requirement or a penalty for a judge who doesn't recuse himself. There is a requirement. It's an ethics requirement. But there's not a penalty. I mean, there's nothing that says if you break the ethics rules that you can be disbarred or removed from the bench. Well, I have to tell you that our founders told us that judges could only sit while they were under good behavior. I would classify a conflict of interest like this as bad behavior. Our third story, and I don't want to minimize the story about these low-level federal judges balking at law enforcement, because this is an important one. These judges are the ones who are, this Judge Fasciola, just to give you an example, he's demanded more focused searches and insisted that authorities delete collected data that prove unrelated to a current investigation, rather than keep them on file for unspecified future use. Talk about a problem begging to occur, right? He has also taken the unusual step for a magistrate judge of issuing a series of formal, written opinions that detail his concerns, even about previously secret government investigations. Here's a sample. For the 6th time, wrote Judge Fasciola testily, using italics in his ruling, and he italicized the word 6th. For the 6th time, this court must be clear. If the government seizes data it knows is outside the scope of the warrant, it must either destroy the data or return it. It cannot simply keep it. When questioned about this for the purposes of the article, the Justice Department refused to respond or comment. It did say in an appeal that his position was unreasonable. Their words, not mine. Out of step with other judges. And that it would slow searches of emails of criminal suspects to a snail's pace. Well, has anyone forgotten the concept that it's not our job to make things easy for the police state? And that leads me to our last topic. And this is the one that every American should recognize is coming, because you and recognize how dangerous this one is, because you can count on 9 to strip you of 10. What do I mean by that? You can count on 9 to strip you of 10. 9 judges that will strip you of 10. The first 10, the Bill of Rights, the liberties, and the constitutionally delineated and guaranteed rights that you have been given by your Creator and by nature itself. Constitution didn't grant you those rights, just outlined them, put them in writing, and guaranteed, putting on notice the whole world that those rights were yours and unalienable and untouchable, unmodifiable, but you can count on 9 to strip you of 10. Because the Bill of Rights is dead. Dead, dead, dead. I can give you an instance without previously thinking of it, and I could pull every one of the first 10 amendments in the Bill of Rights and give you an example in recent current events where it's been stripped. And the courts have backed it, approved of it. Well, I want to bring to your attention another statement from our friend, Mr. Jefferson, in which he clearly addressed this issue. Quote, "You seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. The Constitution has erected no such single tribunal." You know I love to read these twice. And I'm gonna. Because this one is so important. It is such a clear, unequivocal statement. And it is perfectly suited. It describes exactly where we are. You seem to consider the judges as the ultimate arbiters of all constitutional questions. In other words, I don't understand where your thinking is coming from. I don't seem to understand how it is that you believe judges are the ultimate arbiters of all constitutional questions. It's a dangerous doctrine indeed. And one that would place us under the despotism of an oligarchy. An oligarchy manufactured and created and made up of black robes. And then to prove his point, he goes on to say, the Constitution has erected no such single tribunal, essentially saying to you and I, make no mistake about it. We offered and authored and gave or granted no such power in the document that is supposed to be the guidance, the pathway, the framework, the infrastructure, the rule book. But we've allowed judges to tell us, well, we are the final arbiters. Since when? When does a justice have the right to say, we can rule on whether a cell phone search without a warrant is legal? Need I remind you that just because something's a law does not make it legal? I keep hearing, it's the rule of the law of the land, this Obamacare thing, and you will follow it. It's the rule of the law of the land, this BLM ownership of land, 84% of an entire state, and it's the rule of law. Is that so? Is that so? Well, I seem to remember that there were some other rules out there, and there were some other laws out there. Let's see, there was this thing called slavery. At one point in time, that was actually considered to be legal. And it was okay, not only for you to have slaves, but there was this other thing that said if you caught one, you could literally beat him. Then there was the one that said it was okay for you to abuse your slaves your female ones sexually. Then there was the one that said if one of your slaves escaped, you had the right to force others to assist you in actually capturing and bringing him back. Then there was this thing that blocked women from that pesky thing called the vote. Then there was this other one that, blocked everybody from drinking. It was called prohibition. There was this other thing that said it was okay to segregate schools at one point in time, and that black and white children should never be forced to go to the same school together, or much less live in the same neighborhood. In fact, as I recall, there were these signs over the water fountain that said blacks aren't allowed to drink out of this fountain because you might get black cooties. We don't even have to go to Hitler and Stalin or Mao to see about law that's been passed that really has no basis in reality or fact or justice. We've got plenty of our own examples right here, many of which were ruled on by 9, I might add. You see, the problem here is that just because something's passed as a law doesn't make it right, doesn't make it legal, doesn't make it ethical, doesn't make it moral, and absolutely, positively doesn't make it constitutional. Law, when it is the rule of men and the laws of men, not objective, but subjective. When law is outlined where its prosecution can be done selectively, there is no law. That, ladies and gentlemen, is the very definition of lawlessness and anarchy. And anarchy is described as he who has the most might is in the right. And I defy you to find one example in our society today where that rule is not applied. 9 justices will shortly be determining, without authorization, without permission, our fate. I find that a travesty. In fact, I'll go one step further. You can call it what you want. You can use any word or phrase you like to describe it. But treason by any other word is still treason. You're listening to America's Voice now. We're going to take a quick break. When we come back, we're going to talk about antidepressants and how they cause psychosis, dangerous, violent action, self-harming action, suicidal ideations, not only to the person who's actually taking them, but to those around them. If you take an antidepressant, I strongly encourage you to do everything and anything in your power, and this is not medical advice, so you can't sue me, to get off of them quickly, like they're the plague. Think of it like you're just taking an Ebola pill or a leprosy pill. We'll be right back.